Hello friends, in today's session we are going to discuss the case Shri S.Gopal Reddy versus State of Andhra Pradesh. Let us first understand this case in brief. This case relates to section 304B dowry death and 498A cruelty of the Indian Penal Code. The appellant was an officer of the Indian Public Service. The complainant Shri Narayana Reddy was searching for a suitable groom for his daughter Vani and initiated discussion with the first accused. Before the marriage demands were made by the groom's side for cash, jewelry, property, clothes and a car. When these demands were not fully met, the marriage negotiations broke down, leading the complainants to file a complaint against the accused. The Supreme Court held that the term demand for dowry is not limited to demands made after marriage. If any demand is made in connection with marriage or even before the marriage takes place, it will still fall under the definition of dowry, regardless of whether the marriage is solemnized or not. Such a demand is punishable under Section 4 of the Dowry Provision Act and the relevant sections of the IPC. The court clearly stated that any demand for dowry, whether direct or indirect, constitutes a criminal offence. This judgment presents a strong legal stance against the social evil of dowry. Let us now study this case in detail. Answer: Shri S.Gopal Reddy, Appellant versus State of Andhra Pradesh. Respondent. Citation: 1996 for SCC 596. Subject matter of the case: the present case pertains to section 304B and 498A of the Indian Penal Code 1860. Section 304B deals with dowry death, while section 498A addresses cruelty related to dowry. These provisions aim to protect women from harassment and cruelty arising from dowry demands. Facts of the case: the appellant referred to as the first accused is the younger brother of the petitioner, referred to as the second accused in the SLP criminal number 2336 of 1990, which was dismissed by the court on February 15, 1991. The first accused had been recruited into the Indian Police Service and began training in 1985, after which he was posted as an Assistant Superintendent of Police in the Jammu Kashmir Police Force. The second accused, his brother, was working at Osmania University, Hyderabad at that time. The complainant, PW1, Mr. G. Narayana Reddy, was an advocate by profession. PW1 was the father of 4 daughters. His eldest daughter, Miss Vani, was working as a cashier at the State Bank of India in Hyderabad. While looking for a suitable match for his daughter, PW2, a mutual acquaintance of the appellant and PW1, suggested that they marry the first accused. PW2 later introduced PW1 to the second accused. Subsequently, Ms. Vani met the first accused and both agreed to marry. The first accused later saw Ms. Vani at the Institute of Public Enterprise and both consented to the marriage. PW1 promised to give his daughter a property in Hyderabad, jewelry, cash, clothing worth approximately rupees 1 lakh and rupees 50,000 in cash for the purchase of a car. The first accused wrote several letters referencing the dowry, including one with a bank draft. The prosecution claimed that when PW1 contacted the second accused to fix the wedding date, the second accused demanded rupees 1 lakh instead of the earlier promised rupees 50,000 for purchasing a car. Later, the amount was negotiated to rupees 75,000, which a condition that the demand be paid before the marriage. The first accused recommended that rupees 50,000 be paid immediately for the car and the remaining rupees 25,000 within 1 year of the marriage, but but PW1 refused. Later, the second accused demanded a double-story house instead of the single-story one provided, threatening to cancel the wedding if the demand was not fulfilled. Displeased by the failed negotiation, PW1 filed a complaint on 22 January 1986 with the director of the National Police Academy, where the first accused was undergoing training. Consequently, both the first and second accused were charged and punished for offences punishable under Section 420 of the IPC, along with Section 4 of the Dowry Prohibition Act. Case analysis. In S.Gopal Reddy versus State of Andhra Pradesh, the Supreme Court held that the expression demand for dowry must be construed narrowly. It observed that any demand for dowry property or valuable security made by the groom, his parents or relatives from the bride or her relatives at or before or after the marriage constitutes dowry if such demand is not in connection with a legally enforceable claim. This principle also applies in case of proposed marriage, especially when the marriage does not materialize due to unmet dowry demands. Legal measures to prevent the menace. To eliminate the evil of dowry from Indian society, the Indian Parliament enacted the Dowry Prohibition Act in 1961. It was the first legal framework to prohibit the giving, taking and demanding of dowry. Section 4 of the Act especially criminalizes the act of demanding dowry in the context of marriage, even if such demand does not relate to a legally recognized claim. Any person who directly or indirectly demands dowry from the bride or her family can face imprisonment of up to 6 months, a fine of up to Rs 5,000 or both. Under Section 304(b)(2) of the Indian Penal Code, if a woman dies due to dowry-related reasons, the perpetrator can be punished with imprisonment of not less than 7 years and up to life imprisonment. Similarly, Section 498A of the Indian Penal Code provides that if a husband or his relatives subject a woman to cruelty, they may be punished with up to 3 years of imprisonment and a fine. Conclusion. In ancient Indian marriage traditions, dowry was not a demand but a voluntary gift given by the bride's father. There were no expectations or demands from the groom's side. However, in modern times, particularly among the educated class, dowry has taken the form of a demand. Grooms and their families often demand exorbitant dowries, making it difficult for ordinary families to marry off their daughters. To control this malpractice, the government has enacted legal provisions that classify dowry demands as criminal offences. Those demanding dowry can face criminal prosecution. However, legal provisions alone are not sufficient. The complete eradication of this social evil requires a change in societal mindset at a fundamental level. Please watch full video, share and subscribe to the channel. Thank you.